the Attorney General's office was this morning,
Yes, correct.
when you came into the building?
Yes, correct.
Where did you meet with them?
Second floor, just by the entrance.
Who was a part of that meeting?
Barb and Melanie.
And how long did that meeting last?
I honestly don't know what time it is, so maybe 10, 15 minutes or so.
And did they tell you what they wanted you to testify to?
No, they were asking me questions about whether I was a government employee and basically wanting to know my answers.
Did they give you any information about South Sound 911's legal status?
They did not know.
Do you know what the legal entity status is of South Sound 911?
I do, yes.
What is that?
It is a public authority.
How do you know that?
I kind of am aware of this because I worked on a committee. We don't contribute to Social Security, and I kind of headed up that committee. When we transitioned from interlocal agreement to a public authority, we decided to opt out of Social Security. And so I was made aware of its status and a little bit about what that means.
What does it mean?
That it's a intergovernmental agency that's formed and has a board, a representative of elected officials. That's pretty much as far as I understand.
Do you know whether it's part of any specific branch of government?
I'm not aware of that.
Do you know whether it's part of any specific unit of government?
I can't speak to that.
Do you know whether it's part of any specific division of government?
I can't speak to that.
So when you say that you're part of a committee, what was the name of that committee?
Social Security Advisory Committee, I believe is what we called it.
What years were you on that committee?
It was during the time when South Sound was transitioning from interlocal to the public authority it is now. So 2019 maybe? Honestly, I don't totally recall. And it was maybe 8 months or so, 6, 8 months.
Did that committee have anything to do with the decision to change forms?
No, this was a reaction to that change.
What was your role on that committee?
I was the employee lead representative, would probably be the best way to describe it.
Who told you while you were on the committee that the Social Security, that the form of the government, the form of governance of South Sound 911 was changing?
The director had put that information out prior. It's public knowledge. It's available, I'm sure, on our website under public archives.
My question is, who told you the government form?
The director at the time, I'm sorry, I'm blanking on his name. It's not the current director any longer. Andrew Neiditz, there we go.
Andrew what?
Neiditz?
Neiditz?
Yes, he's since retired.
Did Andrew Neiditz tell you what the change in form of governance meant?
There was details about that, something about how I think there originally was sort of 2 boards, and then that was changing to 1. It was, my understanding, it was just a reorganization for the simplicity of management.
Were you in any way part of the, that information was provided by Andrew Neiditz?
Yes, correct.
Were you part of, in any way, of the decision to change form of governance?
No.
Have you ever reviewed any paperwork associated with the South Sound 911's form of governance?
I believe that public authority document was made public in the board meeting notes, and I'm sure I read it at some point, but I don't really recall exactly what's in it.
So you're saying that you have read the paperwork associated with the change in the form of governance?
Yeah, it's a part of it was a part of the board meeting notes. I'm 99% sure that they put out every month. They have like the meeting minutes and stuff, and they post any documents, budgetary and that kind of stuff in there. I like to keep up on stuff.
What was the title of that document?
It would have just been the board meeting minutes from, again, I apologize on the year, probably it would have had to been, I think, 2019, but honestly, I can't recall. Might have been 2018.
Are you reviewing meeting minutes or the document, the actual document, like the legal documents?
So the meeting minutes will then have, after what was reviewed during the meeting, they'll have all the relevant documents from that meeting attached to it. So it's usually one large, sometimes 50-page PDF or something like that.
And you're saying that you reviewed the actual legal document that changed the governance?
I'm pretty sure, yes.
What was that document called?
I don't know.
What did the document say?
It was just noting that there was a change between, or from being an interlocal agreement to a public authority.
And what did the document say that meant?
I don't know that it did, other than that change was happening.
Aside from Andrew Neiditz, where else have you received, in the document you just described, where else have you received information about what type of entity South Sound 911 is?
Other than in certain places it's listed that it's like South Sound 911 Public Authority, on some of our training materials and stuff like that, I can't think of anything else that sticks out.
And South Sound 911 has a board of directors
Yes, correct.
and an executive director.
Yes, correct.
Do you know whether South Sound 911 is a limited liability entity?
Not to my understanding.
Sorry, you don't think it is, or you don't know?
My understanding on an LLC is that that's something you would, if I'm opening a business on the corner or something. So as far as I know, it's not an LLC, no.
Well, I'm not asking about an LLC, but is it a limited, is it an
Gotcha.
entity that has liability limitations?
I genuinely don't know. You'd have to ask our attorney.
Do you know whether South Sound 911 can be sued directly?
I believe so, yes.
Do you know whether South Sound 911 can sue others?
That I don't know.
Do you know whether South Sound 911 is an independent contractor?
Yeah, I'm going to object to this line of questioning at this point. It's gone far afield from the purpose of this board here.
How so?
I'll withdraw the objection.
Right. You may continue.
One moment.
Just take- So just go ahead and look at my phone. I almost read all of them. Okay, we've got two.
Do you know whether South Sound 911 is part of any specific branch of government?
I don't know. I don't know how to relate that specifically to the organization.
So the answer to that question is no.
Correct.
Do you know the purpose for which Southside 911 was formed?
My understanding is that it was formed to improve the 911 capabilities of the county for police response and fire response.
Where did you get that information?
Just from past discussions about why it was formed. I don't think I was not an employee when the initial formation of the interlocal agreement happened, but I was an employee of an agency that was pulled into Southside 911, if that makes sense. Because not all the agencies signed at the same time. It was kind of this progressive change.
Do you know whether Southside 911 is part of any particular jurisdiction at all?
I really can't speak to that. No.
Do you know whether Southside 911 is governmental or quasi-governmental?
I honestly don't know how to answer that. I would assume governmental, but again, I'm not a lawyer, so I don't know.
You don't know.
No.
Do you know whether Southside 911 operates under any policies of any particular jurisdiction?
We operate under policies that are given to us by all the police chiefs in the county and the sheriff.
In the county?
Yes, correct, in the county.
Sorry. My question is, do you as an employee, let's say, do you have a handbook, an employee handbook?
I understand now. Yes, we do have a handbook, and it's derived from our own policies.
From Southside 911?
Correct, yes.
You don't follow, as an employee, the employee handbook of any particular jurisdiction?
Correct.
Does Southside 911 bill out to individual jurisdictions that it works for?
Yes, it does.
Does Southside have a contract with, for example, Pierce County?
Yes.
Does South Sound contract with every entity that it provides services for?
I couldn't answer that for sure.
Are you aware of any entity which South Sound provides services for that it does not contract for?
Not that I'm aware of, no.
How many agencies do you contract with?
It's, I believe, 17 or 18 law enforcement agencies, but then there's, I don't know how many fire entities, a lot. I think in the 30s,
30 fire entities.
somewhere around there. I don't do anything related to fire, so I'm not aware.
Are the jurisdictions that South Sound contracts with all within Pierce County?
Yes, except for one, which is an animal control agency that services Pacific and one other outside I can't think of right now.
Did you testify in this trial that you were a county employee?
I don't recall.
Well, if you had testified to that, would that be true?
I don't believe so, no.
No further questions.
Hey,
Hello. Mr. Shadle, did you work last night?
I did, yes.
Okay, and when did you get off?
5 a.m.
Appreciate you coming back in. You testified that South Sound 911 was created as a, public authority, correct?
Created as an interlocal agreement and then transitioned to a public authority, yes.
Okay, and who belongs to that public authority?
When you say who belongs, are you talking about, I'm sorry.
Which entities?
Sorry. So South Sound 911, but are you talking about the agencies that we contract with?
I'm asking what agencies are part of the public authority?
Gotcha. South Sound 911.
Yes.
Okay.
What agencies are part of South Sound 911?
I'm
I'm sorry.
sorry,
let me
I'm
ask
not,
you a different question.
sure.
I'll get right to the point. Is South Sound 911 a government entity?
That is my understanding, yes.
And are you an employee of that entity?
Yes, I am.
You testified earlier that you were paid through taxpayer money, correct?
Yes.
Why did you say that?
Because I think that quantifies that it's a government agency, but again, I'm not a lawyer, so.
And how do you know that your paycheck is coming from taxpayers?
Because as I mentioned before, I like to look at board documents, and the budget clearly states that.
Do you receive any benefits through your employment?
I do, yes.
Okay, what kind of benefits do you receive?
We're part of the PERS, Public Employee Retirement System pension, and they offer other assortment of retirement accounts available for personal investment.
Okay, and PERS is P-E-R-S, correct?
Yeah,
And who administers PERS?
the state.
Mr. Shadle, what did you mean when you said that you operate under the policies given to you by the county police chiefs? Can you explain that, please?
Sure. We have I don't believe it's a board any longer, maybe operations committee, I think it's called now. And it consists of different police chiefs and I'm pretty sure, a representative from the Sheriff's Department who dictate our policies on how we handle 911 calls.
That's all. Thank you, Mr. Shea.
Okay.
Do you know whether you have to be a government employee to be part of the PERS program?
I'm not aware.
If I told you you could be an independent contractor working for the government and still be part of the PERS plan, would you have any reason?
Objection, we're part of PERS. That is an incorrect legal statement.
Sustained, but you may rephrase the question.
Well, I'm looking at the Department of Retirement Services website for PERS, and if I was to read you a statement from this website that says that independent contractors could be part of the PERS plan, would you have any reason to disagree with that?
Your Honor, he can't read from a website, and that is misleading. He can ask him what he knows, but that is simply not correct.
Overruled. He can answer, well, he may answer if he's able.
Would you have any reason to believe that independent contractors who are not government employees can be part of the PERS plan?
Based on what you're seeing there, no.
So, based on anything, do you have any reason besides to disagree with that statement?
No, I don't have any reason to.
Did you say that you do not pay into Social Security?
That's correct.
Do you know whether people that are government employees are required to pay into Social Security?
My understanding on that is that when you are a part of a program like PERS, then the federal government allows you the option to not participate in Social Security because you're already participating in a retirement pension program. Does that answer what your question?
Do you know? I guess for yes or no, do you
Oh.
know whether people that are government employees are required to pay into Social Security?
I don't believe they are,
And how do you know that?
because of my time on the committee that I mentioned.
You said that the source of your information that your paycheck comes from taxpayers is by reading a budget.
Yes, correct.
And that's a South Sound 911 budget.
Yes, correct.
Do you know whether South Sound 911 meets the legal definition of a government entity?
I do not know.
No further questions.
State.
No more questions. Thank you.
You may step down. Do not discuss your testimony with anyone other than the attorneys, and I'll have you wait in the hallway.
This doorway or the main hall?
State your preference as to where the witness remains. Not in the courtroom, but where.
No.
Okay.
Anywhere.
They had me out there before, sir. So I was, okay.
Oh, right.
State.
We're looking at WAC 415-02-1110. I'll give everybody a minute to get on that. Subsection 1, an employee of a retirement system employer other than a teacher's retirement system plan one retiree who otherwise meets the eligibility criteria to participate in a state-administered retirement system is required to establish or continue membership in that system. An independent contractor is not eligible for active membership in any state-administered retirement system, which is PERS. PERS is the Public Employee Retirement System, and as this WAC illustrates, I don't know what they were looking on the website, you can't be a part of PERS unless you're a state employee.
What agency
Now-
promulgated that WAC?
What agency promulgated the WAC? I'm going to have Mr. Serrano look that up while I keep reading here. Your Honor, the question that I asked him is South Sino 911 a government entity? And he said, yes. And I asked him if he was an employee of that government entity, and he said yes. He also explained that he gets paid by taxpayer money, and I'm not aware of any private company where the employees get paid by taxpayer money, gets paid by taxpayer money. And that's all that we're required to show here, which is enough information for the jury to conclude that he's a government employee, which he is in the best position to know, and he's testifying very clearly that he is. That South Sound 911 is a government entity, and he's an employee of that, and he gets paid by taxpayer money. And additionally, he's part of a state system that he wouldn't have pension access to if he wasn't a government employee. And the state has offered WIPIC 2.22, that's not the one I want. Yes, WIPIC 2.22, public servant means any officer or employee of government. And sorry, you're all right. Oh, here we go. And then also WIPIC 2.11, government includes any branch, subdivision, or agency of the government of the state and any county, city, district, or other local government unit. There's sufficient evidence for the jury to conclude, without this expert legal analysis of LLCs and whatever those other questions were, that he is in fact an employee of government. He gets paid by the government, he works for a government entity, he gets pension benefits from the government. That is sufficient evidence.
Isn't it true that if the court bought a pen at Staples, a private company, Staples would be paid with public money to buy the pen?
I'm not-
You stated that you're not aware of any private entity that is paid by public money, and the court contracts with all sorts of public entities, like even Staples, to buy a pen. And they would be paid, Staples would be paid with taxpayer money, since it would come from the court's budget, which is taxpayer money, that would go to Staples. So I'm not sure I understand your distinction with respect to that no public monies would be paid to a private company.
You're right. The example that you're giving is a customer purchasing something from a private entity and using government money. What I'm saying is that this government employee is being paid through taxpayer money. That's different than a customer buying something from a private company and then that company receiving money from the customer, which paid with the taxpayer money. I don't think the analogy fits at all. He's paid. Nobody's purchasing anything from this employee. He is paid directly by taxpayers. That makes him a government employee. Nobody else gets paid with taxpayer money.
Well, except for it sounds like from what his testimony is that he is paid from South Sound 911, and South Sound 911 obtains money, taxpayer money, to pay him. So that would be like paying Staples taxpayer money, who then uses that money to pay the employee, wouldn't it?
But Your Honor, South Sound 911 isn't getting its taxpayer money from people purchasing anything from it.
Well, they're purchasing.
The entity is funded with taxpayer money.
Isn't what's being purchased 911 services?
No, it is a government entity that is funded by taxpayer money that he works for. I asked him if this is a government entity, and he said it is. And he gets paid through this government entity. His employer uses taxpayer money to pay him.
Okay.
I-
Anything else?
No, Your Honor, thank you.
Defense.
All right, I'll start where we left off, which is, they asked him directly, do you know whether South Sound 911 meets the legal definition of a government entity? And he said no. I think what is clear from the questioning of both parties, is that this is a very complicated issue, where what South Sound 911 is, where it fits, whether it's a branch of government, if it is, what does that mean? He said repeatedly, I think this, but I don't know. I'm not a lawyer. And all of the information he has about what South Sound 911 is not from his personal knowledge. It's from hearsay. He described getting information from a person about what it means. He described reading it in a document. He described reading a budget to determine that South Sound 911 gets money from taxpayers. All of that is hearsay. He has no legal training. He has no legal expertise. He has no experience in corporate forms or government forms. What he knows is what he's heard and what he's read. And that's all hearsay, and it's not within his personal knowledge. As far as, the analogy to Staples, okay, so maybe that's not an example of an entity the taxpayers pay that is sort of like a full company. It's them purchasing. But our firm was working on a case now that supported living company, which is a private company, receives $40 million a year in government funding to administer services for the government. So, and there are road crews that the taxpayers pay private companies to clean the roads. I mean, there's all kinds of examples of private companies. The KLB case is a perfect example. Securitas is a private company the taxpayers pay for. So the fact that the taxpayers are the ones that end up footing the bill for him doesn't mean that they're a government entity. He said it directly, the very last question. He does not know whether South Sound 911 is a government entity. I think to bring him back to testify to this would absolutely confuse the jurors, because this person doesn't know. It's from hearsay. It's what he kind of understands is going on, but he doesn't have any direct knowledge. He doesn't have any personal knowledge. And frankly, I'm not clear where South Sound 911 sits after talking to him. So I'd ask the court to deny the state's motion to reopen its case.
How would anyone know whether they're a form of government? For example, how would the court know that it is a member of a branch of government?
Well,
It would read the Constitution, theoretically, right? But wouldn't the Constitution be hearsay? Or wouldn't it be a document that would not be, wouldn't my knowledge of knowing that I'm a member of a branch of government be from what I would have read from the Constitution and or statutes?
potentially. I think
That's why, how would anybody know whether they were a member of a government entity or South Sound 911 if it is a government entity? How would one learn that other than through hearsay documents that would be outside the court?
two ways. I think one, in the almost every situation, it's self-evident. Pierce County Department of Public Defense, that's a government entity. It's a department of the government. It's self-evident. Other way, and in a case that's more complicated than that, and in this case far more complicated than that, is by a legal expert. And a legal expert can testify to hearsay if it's within the type of documents or the type of information that an expert in the field relies on. So that is what the state should have done in this case, has not. Mr. Shadle is not qualified, has no personal knowledge, and it's hearsay. He's not qualified to testify about this, which is what we argued at the beginning.
State?
Your Honor, I asked him directly, is South Sound 911 a government entity? And he said yes. And then I asked him, are you an employee of that government entity? And he said yes. Now, the defense can certainly cross-examine him on the basis of his knowledge and then argue in closing that Mr. Shadle doesn't know what he's talking about, but his testimony will be that he is an employee of a government entity, and they can cross him on that, and they can argue in closing that that element hasn't been met. But he should be able to testify to his own personal knowledge of how he's employed. That's all the state is asking.
Last thing, Your Honor. The information that the state is seeking to get across to this jury is that South Sound 911 is a government entity. And I don't see how this court can let a lay witness testify to that information when the last question he was asked is whether he knows whether South Sound 911 meets the legal definition of a government entity, and he said no. And the state had an opportunity to clarify that or ask him questions to, try to rehabilitate that, and they declined to do so. So I'd ask the court to deny their motion to reopen the case.
That's a weight, not admissibility argument. He can testify to his personal knowledge, and they can cross-examine him on that, and then argue how they wish in closing that the state's testimony didn't meet the burden. But his testimony is admissible.
Your motion, so your last word to the defense.
Nothing further.
The issue presented concerns the definition of public servant under RCW 9A.04.11023. And a public servant is one who occupies, under the definition in the statute, is one who occupies the position of or has been elected, appointed, or designated to become any officer or employee of government. So the phrase is employee of government is what this issue resolves around. This individual has testified that he is an employee of South Sound 911, and his belief is that because he receives taxpayer money, that he is an employee of government and then provides government services, as has been discussed. The court, that is sufficient for the state to reopen the case to present this evidence. And the court agrees with the state that the concerns that have been raised by the defense are ones of weight, not admissibility. The court does not agree with the defense that the state would have to call an attorney to testify about the legal status of this when we have statutes that are in play that the court can read, the parties can read. And his testimony was that he, based upon his knowledge of his entity, is that it's a public authority. That seems similar to like the health district, where the legislature's authorized government to work with city and county governments to work together to create a health district, and then gives the health district power. A health district is a public agency, but it's outside of what would typically be thought of as county government. It's broader than that. I think the transit in Seattle with respect to the light rail is an example of an entity that's government that was created that may serve various other entities. And so that is also a public authority that the government gives. The defense cited the statute about the public authority aspect of this, and so there is sufficient evidence that the state's seeking to elicit that would show that South Sound 911 is a public authority, which would make it government. And if this person, not if, this person is going to testify that he works for that agency, it's a public authority, then he would be an employee of government. So that's sufficient to at least allow the state to reopen and allow the testimony to be heard, and then any cross with respect to whether that should be relied upon or not by defense.
And Your Honor, thank you. Would it be possible to do that before noon, given that he's been up all night?
Defense?
No objection.
Agreed. Ready to call him? Because we'll bring the jury back first.
Yeah, I'd like to get him
Fine.
back.
If you would please bring the jury back in the courtroom. So to be clear, the court has granted the state's motion to reopen as it has been presented. The court has still reserved the motion to dismiss on count 2 by the defense. We'll deal with that after this witness testifies. The jury is returning to the courtroom. Thank you. Everyone may be seated. Good morning to members of the jury. The state's motion is granted. The state may call its next witness.
Thank you, Your Honor. I believe it'll be Mr. Shadle.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Have a seat. Thank you. State your name and spell your last name.
Conrad Shadel, Shadel.
Ms. Stratnick.
Thank you, Your Honor. Thank you, Mr. Shadle, for coming back. Did you work last night?
I did, yes.
And when did you get off?
5 a.m.
Thank you for coming back. Mr. Shadle, how was South Sound 911 created?
As an interlocal agreement and then transitioned
Sustained as to the form of the question.
Do you know how South Sound 911 was created?
as an interlocal agreement and then
Objection.
transitioned.
Foundation.
Sustained.
You have to answer yes or no first.
Sorry.
I know you're tired, I'm sorry. Do you know how South Sound 911 was created?
I do, yes.
And how was South Sound 911 created?
Objection. Foundation.
Overruled.
As an interlocal agreement, which then transitioned to a public authority.
Is South Sound 911 a government entity?
That's my understanding, yes.
Are you an employee of that government entity?
I am, yes.
And how is it that you're paid?
Through South Sound 911.
And where does that money come from?
Objection. Foundation.
Overruled. He may answer if he knows.
Objection calls for hearsay.
Overruled.
My understanding from reviewing the South Sound 911 budget, we are paid through contracts with contracting agencies, law enforcement agencies, fire agencies. We also receive direct tax revenue from the 911 tax that you see on your cell phone, as well as other services like fingerprinting and firearms permitting and things like that.
And do you receive pension benefits as part of your employment?
I do, yes.
And what is your pension benefit?
It's through PERS,
And what does that stand for?
the Public Employees Retirement System.
And who administers that pension?
My understanding is that the state administers it.
Nothing further, thank you.
Cross-examination.
Mr. Shadle.
Look,
South Sound 911 is not part of the state government, right?
that's correct.
It's not part of the county government.
As far as I know, no.
It's not part of the district government.
No.
It's not part of any municipal government.
No.
It's not part of any jurisdiction, as far as you know.
As far as I know, yeah.
South Sound 911 is run by a board of directors,
That's correct.
and it has an executive director that reports into it.
That's my understanding, yes.
You're not a lawyer, are you?
No,
You don't have any legal training?
I do not, no.
You don't have any legal education?
I do not.
You don't have any expertise in corporate forms,
I do not.
forms of corporation?
I do not.
You don't have any expertise in the forms of companies?
I do not, no.
You don't have any expertise in forms of government?
I do not.
You don't know whether South Sound 911 qualifies as an independent contractor?
I do not know that, no.
You don't know whether South Sound 911 is governmental or quasi-governmental?
Honestly, I don't know.
Isn't it true that you don't know whether South Sound 911 meets the legal definition of a government entity?
With no legal training, no, I could not say that it meets the legal definition, correct?
No further questions.
Redirect.
No redirect, thank you.
To the state, may this witness be excused?
Yes, please.
To the defense, may this witness be excused?
Yes.
You are excused. You may step down.
Thank you, sir.
The state may call its next witness.
Here are state rests.
Defense?
No rebuttal, Your Honor.
Does the defense rest?
Yes.
Members of the jury, at this time, well, it's going to be, are there lunches here? I should ask that first. All right, they're on their way. So your lunches are on the way. I'm going to have you retire to the jury room for lunch. There is some matters I need to talk with the attorneys about. You've heard the testimony in the case, but I need to discuss with them the law that the court should instruct you on, which I talked about this at the beginning of the case. So now we're developing what that will look like, and then we have to make a lot of copies for everybody once I decide what the law is. So that does take a little bit of time. Thank you for your patience. No talking about the case with anybody and no research about the case. So at this point, the jury may return to the jury room. The jury has exited the courtroom. Everyone may be seated. Defense, anything, argument you'd like to present on your motion to dismiss count?
One moment.
Your Honor, we move to dismiss count 2 for lack of evidence that Mr. Shadle is a public servant. His testimony today did not establish facts from which a reasonable juror could find beyond a reasonable doubt that he is a government employee. He testified himself. He doesn't know whether South Sound 911 is a government entity. And he testified that he has no legal training, no legal education, no expertise in government forms, no expertise in corporate forms. He did not provide sufficient evidence to have this case go to a jury, this charge go to a jury, so we move to dismiss count 2.
Just the brief response of before, that it's a weight, not an admissibility issue. He testified that he works for South Sound 911, how it was created, that it's a government entity, and that he's an employee of that. And they can certainly argue that in front of the jury, but it is a halftime motion, so taking all inferences in the light most favorable to the state believes there is sufficient evidence for the jury to decide this issue.
Defense, last word.
Nothing further. Thank you.
State versus Salinas, 119 Washington 2nd, 192, a 1992 Washington Supreme Court case. Cites the case of State versus Green, 94 Washington 2nd, 216, a 1980 Washington Supreme Court case. The test the court is to use concerning, with respect to the defense motion to dismiss count 2, is that the test for determining sufficiency of the evidence is whether, after viewing the evidence in the light most favorable to the state, any rational trier of fact could have found guilt beyond a reasonable doubt. When the sufficiency of the evidence is challenged in a criminal case, all reasonable inferences from the evidence must be drawn in favor of the state and interpreted most strongly against the state. A claim of insufficiency admits the truth of the state's evidence and all inferences that can reasonably be drawn. The defense previously moved to dismiss count 1, the false reporting statement, and the court went through a lengthy discussion as to the facts in the light most favorable to the state. The court's going to incorporate that here. There's no need for the court to repeat that. Specifically for count 2, making a false or misleading statement, the state must prove that the defendant knowingly made a false or misleading statement to a public servant, and that's been the issue, and the statement needs to be material. That's what I discussed earlier. So the issue, as the defense has raised, was a false statement made to a public servant. RCW 9A.04.110, parenthesis 23, defines a public servant to mean any person other than a witness who presently occupies the position of, or who has been elected, appointed, or designated to become, any officer or employee of government. So it's any person that is an employee of government is defined as a public servant, which would then be incorporated into the false or misleading statement statute. Assuming that all the testimony of Mr. Shadle is correct and is true, which the court is required to do at this stage, there is sufficient evidence that Mr. Shadle is a public servant under the making a false or misleading statement. So for those reasons, the defense motion to dismiss count 2, the false or misleading statement, is denied. Anything else from the defense on that?
No.
From the state?
No, Your Honor, thank you.
We do have 15 minutes here. The court did get a chance to review the the defense proposed in jury instructions. And as I did with the defense, I'd like to go through with the state and see if the state has any objection to the defense proposed instructions. We've already talked about some of them briefly, but I do want to know the state's position on it. So is the state ready to respond with respect to the defendant's proposed instructions to the jury?
Yes, sure, in 30 seconds, I'm just reading from the We're ready.
And I said I was going to start with the state, but I want to clarify what I think. We'll start with the states. The defense proposed WIPIC 401. And in looking at this, it looks like it's similar to the state except for the abiding belief language. But is that the change? And if not, what other changes may there be from the defense perspective?
That is the change. It's the removal of the last sentence of the state's instruction about abiding belief.
And I think that's bracketed in the WIPICs.
Exactly.
State.
No response other than we prefer ours.
Fair.
Well, the bracketed information is optional, but I think it is helpful to the jury, and that's why we included it.
I can say, as a former lawyer, based on the side I have argued both your sides, and I was convinced I was right when I argued both your sides. The abiding belief language, it's ancient in our law. It used to be part of the WIPIC that was not bracketed, and then I think the WIPIC committee, I'm sure the WIPIC committee then looked to say, should we keep that in? Case law supports it, and the WIPIC committee, and I was a longtime member of the WIPIC committee, is guided by, if it's the law, you say that's what the law is, you don't make policy decisions about that. So the WIPIC committee is limited from that. And so when they decided to make it brackets, it was realizing that the case law affirmed an instruction that gave it, but doesn't necessarily say it's required. I'm going to give the defense version of this. It doesn't, I don't believe it harms the state's ability with respect to what reasonable doubt means, and to be honest, if the defense wouldn't have proposed their own, I would have given the states. I think this is an area that could use clarification, but both are correct. And so since the defense is asking for this one, the defense is I'm going to give their version of WIPIC 401. Of course, then we'll take exceptions when we get to those so the state can respond if they want. All right, to the state, WIPIC 126.15 and then the RCW is about the definition of false reporting. Does the state object or not?
Yes. It seems to, you want to know the basis?
No, I just wonder if you're going to object, because when we get to the basis, I want the defense to go for, on their instructions like I'll do with yours, to argue why you think that's correct. So for now, I just want to know which ones you object to. Cause, proximate cause, object?
Yes. Yes, we object.
The false reporting to convict?
Yes, we object.
The next one, WIPIC 2.22, modified by KLB, about public servant definition.
No objection to that one.
The court will give that instruction. Definition of knowledge. Looks like in this one, the second, knowledge has multiple paragraphs, and if I read this correctly, it looks like the second paragraph was deleted from the states, but I may be wrong about that. So defense, the change in this from the state's version?
Yes, the second paragraph is deleted.
Is the first paragraph modified from what the state requested?
Yes, I believe it is.
All right.
I have too many tabs open, so it's trying to go through them. Yes, it is.
State.
I don't have all those tabs, but I need a bigger table. Hold on. And they didn't just delete the second part of the WIPIC.
Is it fair to say the state objects?
Yes, Your Honor, sorry about that.
Other than what the defense has, Provided to the court on proposed instructions of the jury. Do you have any other instructions you'd like the court to consider?
Not at this time.
The court's going to start with the state's objections or state's instructions, and then I know the defense has indicated some they object to, so I'll go ahead and let the state start with why its version, and then it looks like there may be some contrary versions, and then I want to hear the defense argument as well. So the first item, so let's start from the beginning with the state's instructions. Oh, any objection? I didn't ask this. Any objection to the cover page that the state provided under WIPIC 101.01? Just it says court's instructions to the court, dated, and then my signature. This one.
The one that says plaintiff's proposed instructions.
Well, no, this is the first page, but the second one, this would typically be,
Oh, sorry.
although I do say it's not a Sultan County, so we got to change that. But it's the one that would, in fact, I think,
Yeah, the Sultan County part, I would remove.
Oh,
and actually I see the defense prepared one as well called court's instructions to the jury. So I'm glad we caught that. So to the state, any objection to using the defense proposed court's instruction to the jury? It's WIPIC 101.01, does say Pierce County.
yes, let's use theirs with the correct county.
Instruction, we already talked about the WIPIC 102, defense had no comment. The WIPIC 301, separate crime, defense, you wanted to reserve on that?
No comment now.
The next one we already talked about, and the court already telegraphed what it was going to do, but it's the WIPIC 401, and that the state's proposing with respect to abiding belief. We've talked about it. I'm going to give the defense version. State, anything you want to say about that?
No, Your Honor.
Defense objected to WIPIC 6.41, weight and credibility of out-of-the-court statements of the defendant. So state, why would you like that to be given?
I think it's an accurate statement of the law, and therefore I think it should be included, particularly in a case where the case really is all about the statements that were made out of, well, not completely, but to a very large extent, that's exactly what this case was about, what people said at the scene, what they said to 911. These are all party admissions by the defendant, and I think that the context and nature of those statements is at the heart of this case, and therefore I think it would be helpful to the jury to have that.
Defense.
This instruction, based on the comments, is used for if there's a confession, a challenge to a defendant's confession, the voluntariness of it, and that's not an issue in this case. It says that the instruction is unnecessary when the prosecutor offers an alleged confession to a private person. Anyways, the entire comment section is that this is to be used for confession cases, which this is not, so we'd object.
Okay.
No response beyond what I said.
Yeah, looking at WIPIC 6.41, the note on use by the WIPIC committee starts with this instruction must be given upon request of the defendant when after a hearing, and then goes from there. The defense is not requesting this instruction, and to the contrary, the defense objects to this instruction. Given the reasons for this instruction and the comments that are made by the WIPIC committee, the court is going to decline to give WIPIC 6.41 as proposed by the state for the reasons the defense has discussed. The next one is, defense is an alternate from WIPIC 126.15. This is definition of false reporting. So state concerning your proposed version of 126.15.
Your Honor, ours is taken directly from the WIPIC, and it's taken directly from the statute. There's adds some elements that are not in the statute, and that's why we think ours should be used.
Defense, I have both of them right here now, so your response.
The false reporting statute includes under section 6 that nothing in this section will be construed to impose liability on a person who contacts law enforcement for the purpose of or in connection with the reporting of unlawful conduct. So what that says is that a person can't commit false reporting if they contact law enforcement for the purpose of and in connection with the reporting of unlawful conduct. So I think it's an accurate statement of the law, something a jury needs to decide.
You're referring to RCW 9A.84.0406. Is that correct? Correct. State.
Your subsection 6A's reference to liability is to civil liability, not criminal liability. The rest of subsection 6 deals with civil statutes, so 6A logically also deals with civil liability. 6B deals with clarifying that there is no conflict with the Communications Decency Act, which similarly protects good faith reporters of lewd materials on the internet from civil liability. And then C2, 6C clarifies that there is no conflict with 42 U.S.C. 1983, which governs civil suits based on violations of constitutional rights. This is about civil liability that may or may not attach to this. Now, a principle of statutory construction is that a single word in a statute should not be read in isolation. That's from State v. Rodenkamp, 153, Win 2nd, 614, 2005 case. Instead, the meaning of words may be indicated or controlled by those in which they are associated. State v. Jackson, 137, Win 2nd, 712, a 1999 State Supreme Court case. So, in summary, because Section 6A's references to liability are the same, 6A's reference to liability is in the same subsection as other terms respecting civil liability. It's also a reference to civil liability. Now, more importantly, this isn't part of the WIPIC, and the reason it isn't part of the WIPIC is it's not an element of this crime. Okay, the elements are listed in subsections 1 and 2, and this is not listed in either one of those sections, so it's not an element of the crime. They've added it to the WIPIC and are asking the state to prove a negative beyond a reasonable doubt. So it's clearly not an element, and even if the court were to read into the language of that statute, it requires actual unlawful conduct, and the call to 911 did not include any actual unlawful conduct. Driving around late at night is not unlawful. None of what is described is per se criminal, and there's no evidence that Mr. Altheimer committed a crime of any kind. Subsection 6 cannot serve simply to protect good faith reporters of something that is possibly, but not upon further investigation, not unlawful. That would be redundant with the requirements of subsection 1, which already protects good faith reporters by requiring that the prosecuted person know that their report is false. So reading subsection 6 as redundant with the falsity requirement of 1, subsection 1 is not permitted. Statutes must be interpreted and construed so that all the language used is given effect with no portion rendered meaningless and superfluous. Also, the statute has to be read to avoid absurd results, and courts also presume that the legislature does not intend absurd results and, where possible, interprets ambiguous language to avoid absurd results. And the reading here seems to be that, if I understand it correctly, if you call in a false report that triggers an emergency response, but then you also add in some of this other language about something that isn't an emergency, that somehow you're then shielded under the statutes from being prosecuted. And that's clearly an absurd result. It's not in the WIPIC because it's not an element, and it's not an element because it is a separate subsection at the bottom of the statute, which is specific to civil liability.
Mr. Ross. Subsection 6 refers to the section being the entire section. The word liability, it doesn't say civil liability. There's, of course, criminal liability. That goes without saying. While this describes that it does not impose liability for a certain thing, the other two are not in line with that. They talk about conflicts of law. Subsection A doesn't deal with conflicts of law at all. So what Section 6 seems to be is a catch-all provision that describes both conflicts of law and also that the statute may not be violated if you are contacting law enforcement to report unlawful conduct. And it's not an absurd result that this part of the statute exists because in fact it's exactly in line with what I've been arguing as far as proximate cause. The state, if a person calls 911 or law enforcement to report unlawful conduct, the person does not violate the statute by or unlawful conduct that could generate an emergency response. The person does not commit false reporting by also reporting false statements. So it's not an absurd result. In fact, it makes perfect public policy sense. So I disagree with that. Finally, if the court finds that liability is ambiguous, again, that goes to the rule of lenity, and that has to be interpreted in favor of the defendant.
Does the defense, looking at Section 6A, impose liability on a person who contacts law enforcement? Is Southbound 911 law enforcement?
That's a question for the jury to answer.
What element in the false statement concerns law enforcement?
The emergency response section.
So the defense theory would be that the 911 is a law enforcement agency.
No, the theory would be that the purpose of contacting the dispatcher is to contact law enforcement, to get in contact with law enforcement.
Anything else?
Nope.
Just briefly that, again, the elements here are in subsection 1 and 2, and then after that you get into things like definitions, what to do if somebody's under the age of 18, that would be a diversion under subsection 4. So anything below 2 is not an element here, and that's why it's not in the WIPIC. And it does pertain to civil liability. That's a clear reading of that statute, and the court's point is well taken as well.
Anything else, Mr. Rose?
No.
The court is going to give the state's proposed version of 126.15 and deny the defense version for two reasons. The statute that the defense is raising, Section 6, mentions liability, and when you read that statute as a whole, it's focused on civil liability. When you look at the specific items that were in Parts B and C, a logical reading of that is concerning civil liability. If the court's incorrect about that, A, which is what the defense is relying upon, is that when someone contacts a law enforcement agency with possible unlawful behavior, and there's no evidence the courts heard that Southbound 911 is a law enforcement, and so for that reason it wouldn't apply, even if this Section 6A is intended to apply to criminal liability as well. So for both those reasons, the court's going to give the state's version of 126.15 and deny the defense version. The next state instruction is the to convict instruction for false reporting. The defense has provided an alternative. So, to the state.
Sorry, I was looking for a cough drop.
Which one are we looking at, Your Honor?
It's the one that starts with two convicted defendant of crime of false reporting in the state's version, and the defense has a separate version with, looks like it's added a new paragraph 4 in just comparing the two. So it's a definition, it's a to convict instruction for false reporting.
Should I go first?
Yes.
Yeah, sorry, I just needed something for my throat. Yes, there's adds an element, which is element 4, which is what we just talked about here. It's also asking the state to prove a negative. It's also not in the WIPIC, so I don't think that that is an element of the crime, and therefore it needs to be removed.
Defense?
I'll just incorporate my argument about the previous instruction.
Understood. So the court is going to give the state's proposed RCW 9A 84040 to convict instruction concerning false reporting, and will deny the defense version, which adds a new paragraph 4. The next is WIPIC 2.22, the definition of public servant, and the defense has an alternate definition, state.
I actually agree with the state's, I agree with the defendant's version. So I withdraw ours and ask that the court use theirs.
Defense?
That sounds good to the defense.
Next is the state's WIPIC 2.12, definition of governmental function. Just a second, I need to change my notes here.
And just to clarify, our request is to strike this one.
And we've moved to, I just need to glance at it to be sure, but I think we're going to withdraw it. Yeah,
Okay.
as soon as we find it. We're going to withdraw that instruction, Your Honor.
On the prior one, I made an incorrect note, and I want to make sure my notes are correct, so my apologies for that. So concerning the WIPIC 2.12, state is withdrawing. Is that correct?
Yes, Your Honor.
Any objection?
No.
Next for the state is WIPIC 10.02. It's the knowledge, knowingly instruction. The defense has an alternate version. State.
Your Honor, the state says the WIPIC, which includes all three bracketed definitions of knowledge, all of which I think apply here, but more concerning is that they've inserted in theirs language that isn't in the WIPIC and isn't supported by the law when he or she is actually and subjectively aware of that fact. That is not an accurate statement of the law, and I think it needs to be removed.
Removed, or is the state still seeking its proposed 10.02?
Yes, Your Honor.
Defense.
I think it is an accurate statement of the law, and the comments to the WIPIC support it. The language of, let's see, sorry, just give me 1 second to pull it up. The WIPIC language says that he or she is aware, and if the comment in the actual awareness section says the person must be, quote, actually aware, end quote, and it also says that actual subjective knowledge is required, and it cites the case, Supreme Court case of State v. Shipp. So it's an accurate statement of the law, and I think that more explanation is needed to the jury about what aware means.
Dave?
There, I think the definition of aware is well known to everybody. I haven't read that case specifically, but like I said, the WIPIC does not insert that language. And if the WIPIC committee thought that that was something that the jury needed to be aware of, they would have inserted it.
Anything else, Mr. Gross?
I just asked this court to give the instruction that we proposed in full.
The court is going to give the state's WIPIC 10.02 and deny the defense modified version of that instruction. Switching to the, were there any other than what we've talked about to the defense, was there any other instructions about the state that you would want to have the state's proposing, other than what we've already talked about?
I just want to make sure that we move to strike 2.12. That one was withdrawn, I believe. Okay. And the court declined to give instructions 6.31 and 6.41.
Yeah, I know the answer to the first question was the court did, but
That matches what we have.
the court's not giving WIPIC 2.22 and 2.21. That's correct. That was withdrawn by the state, so the court's not going to give that. And so the court is going to give defense version 4.01. Declined WIPIC 126.15 modified. Proximate cause. So the defense, you proposed a definition of proximate cause based on state versus buyer, and the state's objected.
If it's okay with the court, I'll incorporate my argument earlier as to the motion to dismiss count 1 as far as why proximate cause is the right instruction for this case.
Right? Anything else from the state on that?
No, Your Honor, thank you.
The court's going to decline to give the defense proposed instruction of proximate cause for the reasons we've already talked about.
Did we address WIPIC 2.11? I'm not sure we addressed that one.
Provided, proposed by the state,
Yes, Your Honor.
2.11.
And the defense didn't take exception to this one.
Then, okay, I'm just making sure it's been given.
Okay. I think we've talked about all the instructions. I have a couple questions about order of the instructions, but to the defense, have we talked about all the instructions at this point?
As far as I'm aware. And
state-
again, what I'd like is if the court could send us copies, we could review them over lunch. And
We'll see how quickly I can get to them, but yes,
Okay.
that's a goal for sure.
Okay.
But it's going to take a while to make the copies.
But thank you.
With respect to the order, the defense, and the court agrees, I think I'll start with it. With respect to the order, it's my general practice for a crime, to start with the definition, include all the elements that the parties have requested, and then end that discussion about that particular charge with the to convict instructions. So that's generally the order I prefer, but I'm certainly willing to modify my perspective because there's no real instruction from the WIPIC committee as to how the orders should be. The state also had one final one at the end about the juror's duty to discuss, and I've already indicated my preference would be to put that much further ahead in the discussion, so the juries are told very quickly they have a duty to discuss, but it doesn't matter the order in the sense that the jurors are going to be expected to follow all the instructions. So if you have thoughts about the order of what you would like, let me know. State?
The state really has no preference.
As far as the order definition of this crime, definitions relevant to determination of the crime and to convict instruction, that's fine with defense, the order that the court stated. We would prefer to have the duty to discuss instruction given at the end, just because we think it's good for the jury to hear that just before they go in, sort of procedurally what they should be doing, and have that top of their minds when they start deliberating, but we don't feel strongly.
Well, the state proposed to put it at the end. That's where the defense wants it, so that's where I'm going to put it unless you have an objection. And interesting discussion I'll have to think about, but won't be for this case. So I'll put the whip at 1.04. That'll be the final instruction before the verdict forms. I realize some of this order makes a difference in how you want to do closings as well, and that's why I asked about it, because I want to make sure that at least the order is consistent with how you would want it to be told to the jury before closings. So looks like everybody's on their hands. All right. Yes.
There was one more matter about whether or not the exhibits would go back to the jury room with the ability to play them.
Talk about that after lunch, but you brought it up, so here we go. So sure, what's the state's perspective on whether the jury should have playback devices in the jury?
What's your perspective? I'm just going to see if we agree or not, because if we agree, then I'm not going to bother making an argument.
This is the case of State versus Castellanos, 132 Washington 2nd, 94. It's a 1997 case.
The parties agree that we'd like it to go back there with the ability to play it, correct?
Correct.
Right. That keeps you from having to come back when the jury sends me a question about that, so I can appreciate that strategy. So we will do that. My understanding is that there's a device that they would be able to put this evidence, these exhibits into, play it, but there's no Wi-Fi connectivity. There's nothing other than the ability to play back whatever they put in there. And I believe there's also a monitor that's attached to the device, clerks are, so that they would be able to see it on a bigger screen than just on a small.
Oh.
What is it, a laptop? It's a laptop, but the laptop has the screen's attached, so it's bigger. So that's my understanding of what would go back there. So having no objection, the court will grant that, so we'll make sure the jury has the playback devices. State, anything else?
No, Your Honor, thank you.
Would the jury be able to request to come out here and watch on a bigger screen?
Jury questions are an interesting topic for discussion.
Okay.
It's difficult to predict that. Would you want me to tell the jury they can do that, or would you just want to wait to see if they have a question, and then we'll respond and bring them out here if that's what they ask?
I guess wait to see if they want to.
So I'd like to give these instructions to you now, but I have to go through them, make sure they're in the correct order, and then staff needs time to make all the copies, so it's probably not going to happen until after lunch, and I know that may delay everybody, but staff needs a lunch too, and so let's have a lunch and be back here. It's already 12:20. By 1:30, that gives me a few minutes also so let's be back by 1:30 for lunch. Court's at recess.
Recording stopped.
is that Mr. Aldheimer left and that the defendant did not. The defendant could have ended this whole thing right then and there and gone home, but he didn't. Now, Sheriff Troyer was the public information officer for the Pierce County Sheriff's Office for 2 decades, the face and the voice of the department's messenger to the public. He had just finished running a successful campaign for sheriff. This is a man who understands the power of words and how to message things. So while safely seated in his SUV, Sheriff Troyer makes a direct call to a 911 dispatcher, identifies himself, and knowing the effects that his words will have, he tells the dispatcher this. Yes.
House and I caught some in my driveway.
Oops.
Just tried to kill them and I blocked them in. He's here right now.
Okay. Go again with.
Okay, I'm trying to get back to the beginning of that.
Radio.
Hey, it's Troyer.
What can I do for you?
I'm at 27th and Deidre in Tacoma in North End. About 2 blocks from my house and I caught some in my driveway. He just tried to kill them and I blocked them in. He's here right now.
Okay.
Relying on what Sheriff Troyer told him, dispatcher Conrad Shadell believed that the sheriff was in an active confrontation with a man outside his home who knew he was a police officer. Mr. Shadell typed in the information the sheriff had given him. This information was then seen by fellow dispatcher Leah Heiberg, who was dispatching to North Tacoma that night.